following amendment, the clerk will read the amendment.
Amendment by King of Parker.
Chair recognizes Mr. Parker, or Mr. King of Parker, to explain the amendment.
Change those cards or something. So. All right. Thank you, Mr. Speaker, members. This is something that the appraisal district here in actually Travis County asked for, but it's something that's really good for your constituents too. So 2 years ago, this legislature, the problem was you would appeal your home appraisal and you'd go through the appraisal process and you would prevail. They would lower it down. Maybe they appraised it at $200,000. They lowered it, you won, they lowered it down to $150,000. And then 3 months later, you get your new appraisal and it's not just $200 this time, it's $225. And you're going, why did I bother to do that if they're just going to raise it back up? So this legislature, I think unanimously in the House, voted to raise the standard of proof to clear and convincing, that simply said that in the next appraisal, which could be the next year or 2 years, however your county does it, they couldn't raise it right back up unless they had clear and convincing evidence. So basically it gave you an extra year or an extra appraisal period before they could raise your appraisal. Everybody was happy with that. The appraisal districts have done it. It's really been a lot more good than anybody expected until the property valuation study. So what has happened, and Travis County brought this to me a couple days ago, is that the comptroller is not recognizing the fact that the appraisal districts have to have clear and convincing evidence. So they are still holding the appraisal district valuations to the preponderance of an evidence standard. And the appraisal districts are saying, we can't raise their appraisal up because it's a higher standard of proof now. But the comptroller's office is saying, well, we're just not going to recognize that the legislature put that in statute. And so it's hurting your value, it's hurting your school funding. And so all this does, it's a 4-page amendment that just changes 4 words. And all it does is say the comptroller has to recognize in its valuation study the clear and convincing standard that the legislature put in place 2 years ago. And that's all it does. And it was brought to me by Ms. Howard's appraisal district. I thought after 22 years I should do something for Austin.
Mr. Speaker, please.
Ms. Howard, for what purpose?
I am so grateful to Representative King for finally bringing something.
It's been my honor. It truly has.
Thank you so much. I'm sorry, I'm still trying to get my head around what you just said of a 4-page amendment that I heard you
Ms.
just lay out.
Ms. Howard, for what purpose?
Oh, to ask some questions.
Yes.
Maybe answer some too, but ask. Is he okay?
I'm good, yes.
The gentleman
Okay,
yields.
thank you. Still trying to understand exactly what you just said in this layout here. So Travis County Appraisal District asked you to file this, you're saying?
Yes, they
And
did.
can you just repeat in a few words, lay words here for us to understand what the ultimate gist of this is?
Okay, so when the comptroller's office does their study, they're going to tell the district whether or not they have properly valued the properties.
Right.
And so one of the things that makes a difference in that is the appeal process, because they may set someone's valuation at this level, and then they appeal it. It comes down to that. And so when the comptroller's office does their study, they take into consideration the fact that some of those appraisal appeals will be won based on the preponderance of the evidence, and it's going to adjust that. What the effect of the clear and convincing evidence standard did was basically said that you're not going to be able to raise their appraisal up the next year. You have to wait 2 years. And so normally your appraisal district would be coming back in, and if you won your appeal, they would the next year go ahead and raise it back up on the next appraisal. They can't do that now. They have to wait till the next appraisal period, which in some counties is 2 years. In Travis, I think it's 1 year. And so that means that the appraisal district can't raise up as many properties next year as they want to. And the comptroller's office needs to take that limitation, that cap into account when they're setting what your proper appraisal amount should be. And they're not doing that. They're still looking at it from the standpoint of, well, you can raise it right back up the next year, and the law doesn't allow that. And so Travis County said, you've got to make the comptroller's office recognize the fact that we don't get to raise the value on a property up the next year like we always have been because we don't have clear and convincing evidence, and that's holding property values down, but the comptroller's office is not recognizing that.
That is very difficult to get one's head around, but it sounds like you're talking in particular about preponderance of the evidence versus clear and convincing. Is that part of it?
Clear and convincing is the current law that we put into place 2 years ago.
Right.
The comptroller's office is not taking the fact that that limits the amount that they will be able to raise property taxes or raise appraisals in a district the next valuation period. And
So
the
we
comptroller's office isn't recognizing that. This just tells them to.
So
I know
that-
it's kind of heady.
That level of evidence is part of it. Then also part of it is the 1 year versus 2 years?
Yes.
Okay.
Because, again, break it down to just a single house. Let's say you appeal and you get your property on your house knocked down to $100,000. Well, the comptroller's office in their study would expect next year Travis County to raise that right back up to 150. And so they take that factor into their study. But Travis County can't do that next year. They have to wait 2 years.
Even if that's what the market value is?
Yes. Because they don't have clear and convincing evidence.
Aren't we supposed to be basing this on market value, though? Aren't we a free market state and we base things on what the market value is?
Two different things.
Okay.
One is what is fair market value? And if you don't think it's fair market value that they appraised it at, then you appeal that, and the standard of proof
Okay.
that is preponderance of an evidence. We raised it to clear and convincing, which says that that it makes it a lot harder for them that next year to raise your value. We said that if they want to raise it the next year, they better have clear and convincing evidence, which they never do.
Which perhaps sales price disclosure might be helpful here?
Different issue outside the scope of the bill.
Different issue. But part of what we're dealing with here is the fact that we don't have that, and so we're having to figure out how do we determine what is fair, right?
It's all subjective in the world of appraisals.
Okay, thank you.